Hello, everyone. Welcome to Joe the Lawyer. I'm Joe Pometto, a practicing Pittsburgh attorney. Today, we are going to talk about contracts and natural disasters. And the reason I'm talking about this is because all over the news, all over the country, all over the world, we have the coronavirus. The coronavirus is shutting down businesses, shutting down the NBA. The casino in Pittsburgh has closed down. Stores, everything is shutting down. So the question is, these people are losing money. Businesses are losing money. Businesses who have made agreements with each other are losing money, and they may not be able to follow through on the agreements that they made. So the question is, how is that treated under the law? To sum this up, can you break a contract due to the coronavirus? I'm going to go through the legal analysis that a court would go through, and then I'm going to use a real world example to try to make it a little clearer as far as our understanding. When can a natural disaster or something like a pandemic like the coronavirus cause a person or business to be excused from performing on a contract? Thank you very much for tuning in today. If you like my channel, Joe the Lawyer, please like, subscribe, comment, and share. It's a free way to support the show. If I get more subscribers, more comments, it lets YouTube know that I am growing, that people are enjoying my content and that there's some value here. It also motivates me to come out and make more videos. So please like, subscribe, comment, and share. Also, I have an email list. The link to the email list is in the description below. If you sign up, you will get a free PDF on what to do when pulled over by the police, written by yours truly, Joe the Lawyer, free legal advice. Okay, now let's get into what happens when two parties, whether they be businesses or individuals, have a contract and nature intervenes. For example, let's say there is a flood or a hurricane or a tornado. Let's say you contract with a trucking company to ship some goods for you, okay, across the state, and you live in the city like I live in Pittsburgh, okay, and a tornado comes through and wipes out your entire trucking fleet, just boom, boom, boom. Do you still have to perform that contract, or do you have to pay the other party that you contracted with the amount of money that you would have owed them had the contract been performed? Okay, what I will tell you is that it used to be in the old days, early English common law in the 1800s in the United States, that what the courts would do is they would strictly interpret a contract. Even an act of God could not intervene with the application of a contract. So let's say it was back in the 1800s and you had a stable of horses that you agreed for some courier to use to take goods between towns for, let's say, a period of 30 days, and you wrote up this contract, okay, and a disease comes through, a special strand of virus comes through and hits all your horses, and all your horses die. Okay, well, now that guy that businessman who you contracted with, he has all these goods, he can't deliver them because you were going to deliver them, okay, and use your horses. So he's going to lose money. He's not going to be able to come through on his sales, okay? And he is going to lose money because he can't use your horses, okay, to go out and deliver his goods. The question is, do you then have to pay him for the losses, right? He's losing money because you can't perform your contract. Your horses are gone. In the old days, the court would make the horse owner pay money. Now, they might decide on a fair price, may not make him pay the whole amount, whatnot. They'll take it case by case, but that person would no longer be able to perform the contract. He agreed to provide those horses. He could no longer provide those horses. Therefore, he's still obligated to cover the losses of the businessman who was going to deliver the goods. That was the old interpretation. Contracts were very, very strictly enforced, so you had to be really careful. Well, over the decades, over the centuries, the law has evolved. Now, in certain situations, okay, a contract may be dissolved, or someone who has an obligation may not be required to fulfill that obligation if an act of God has occurred. A tsunami, an earthquake, a volcano, a pandemic, something like the coronavirus, which we'll get to at the end. So this new doctrine that was developed in the courts is called the impracticability doctrine. And essentially what courts began to say was, if it became impracticable for that party to perform their side of the contract, okay, they would not be liable for damages to the other party. And impracticable applies in a very narrow way. There are three things that the courts look at, when they want to decide whether or not to enforce a contract or to relieve a party of responsibility under the impracticability doctrine. Number one is called force majeure or allocation by agreement. So first, they're going to look at a contract and they're going to see if the parties specifically planned for this type of circumstance. So for instance, let's say you have a shipping company and you ship goods across the Atlantic Ocean. Well, you know that you are going to encounter storms. So the two parties may specifically talk about what happens if the shipping company can't deliver the goods when a storm occurs. So that's the first thing the courts are going to look at, is they're going to see if the parties in any way whatsoever talked about this particular situation in their contract. Because if they did, then they would still apply what the contract says instead of moving on to the further steps of the impracticability aspect and forgiving one of the parties, right? So the contract may provide, for example, let's say Company A in New York City is delivering widgets to Company B in London via shipping, okay? And they deliver 10,000 widgets every month, and the company in the UK, Company B, pays $5,000 for these widgets. Well, they may write something into the contract such as, well, if a storm hits and the widgets cannot be delivered by the correct date, then party A is automatically forgiven. Or party A, who's supposed to deliver the widgets, all right, gets a discount on the next delivery because they lost money in their attempt to go across the ocean. There's all kinds of ways that you could deal with that and allocate the risk in case a situation arose. And if the party specifically planned for that in their contract, then the court will apply that instead of looking to forgive one party or the other. So this is what you're going to see in the majority of modern contracts and really sort of high-level contracts. The parties are going to plan for these circumstances. Okay, that's step one in the analysis, force majeure, allocation by agreement. Force majeure, that sounds to me like a French word. It may be Latin based. Throw this little golden nugget in there. The language in American and English law generally derives from three languages: English language, Latin language, and the French language. English is easily explainable, right? It's England. That's where English law came from. Of course, the English language, easy enough. Latin, where did that come from? Well, Latin was the majority language spoken on continental Europe during the times of the Roman Empire. But more importantly, I don't know if it was more majority, but more importantly, when Britain, France, Spain, Italy, other parts of Europe, the oligarch, the aristocracy, the rulers, the warlords, the Romans who ruled over the country spoke Latin. So that became the language of law, of business. And then, that's been handed down also through the Catholic Church and through the Roman Church for hundreds and hundreds of years. So, of course, you have Latin mixed into legal terminology. Well, how did French get involved? If you can answer that, let me know. Think about it. Well, no, I'm just going to tell you. Well, in 1066, when the Normans conquered England, okay, the English kings were all of French descent, and French became the language of the nobility for hundreds and hundreds of years in England, between 1000 until basically the 100 Years' War. The kings of England spoke French. Some of them never even spoke English, but that was the language used in the law. So English law and American law, as a consequence, inherited three languages, essentially: English, Latin, and French. Okay, so the force majeure clause is the first step in the contract analysis of impracticability. Step number 2 is the foreseeability aspect. There's actually, let's call that the supervening event. Okay, so what the court's going to do when deciding whether to forgive one party or not is they're going to see if the event that occurred was foreseeable or not foreseeable. So let's go back to our example of the shipping company across the Atlantic. Okay, a storm is foreseeable. Therefore, the court, when doing this analysis, let's say the parties didn't talk about a storm interrupting the delivery of goods in the contract itself. Well, the court may say, you should have predicted that storms would intervene. Therefore, we're going to apply the contract. We're not going to give either party relief because you should have known that a storm would intervene. That's a foreseeable event. However, an unforeseeable event may be something like pirates or an attack from a foreign country. All right, let's say a boat is going across the Atlantic and, the Spanish Navy is out there and misidentifies that boat for an enemy boat of a country they're at war with, and they shoot a torpedo and blow up your shipping boat, okay? That would be an unforeseeable consequence. Therefore, unless, of course, maybe a war is actively going on, it's case-by-case basis, but something like that is largely unforeseeable. Therefore, the shipping company may be forgiven for not delivering the goods. They couldn't have predicted that the Spanish Navy would misidentify their ship as an enemy ship and blow it up with a torpedo, but they could have predicted a storm. So that's the next element, okay? So number 1, no force majeure. Number 2, the event was unforeseeable. And number 3 is the impracticability of the event, which means the extent of the cost increase. This is an interesting aspect here, but if an unforeseeable event damages a contract and a company loses money, okay, over this unforeseeable event, the court may still enforce the contract if the loss is small. Okay, it has to be extremely large. And the reasoning behind this is that every contract carries with it risks. Okay, and you should be prepared to bear a loss of some degree if circumstances arise in the performance of the contract. Now, if the loss is small, the court will not help you out. If the loss is ridiculously large, the court will help you out. So, give you an example. Let's use the boat again, going across the Atlantic Ocean. Okay, let's say The boat is going across, and the Spanish Navy just intercepts the boat. It was unforeseeable, okay, but it only delays the delivery of the goods. So they go and they get the goods to London, and Company B in London charges them a $5,000 penalty. Well, the court may say that's not going to bankrupt the company. It's not so big. We're going to enforce it. You still got to pay the penalty. Okay. However, in that same scenario, if the boat was going across and the Spanish Navy intervenes and blows them up, they may lose $1 million, and then Company B in London loses that entire shipment, all right, which runs into like $1 million or 10 times the cost of the contract itself. Then the court may find impracticability applies. So the extent of the cost increase is relevant. So those are the three-part analysis of the impracticability doctrine. Is the force majeure clause, is there a clause where the parties planned for this? Okay, if no, then they see if it was foreseeable. If it was foreseeable, the courts are still going to enforce the contract. If it was unforeseeable, the courts will then go to the next step of the analysis, which means the increase. How large was the increase in cost? If the cost increase was tremendously large, okay, that would meet the third element, and the court may look at the contract and say they're not going to require either party to pay the other party. Company A doesn't have to pay Company B because what happened was unforeseeable, okay, and the cost increase was tremendous, very, very high. Therefore, they're forgiven and they don't have to pay Company B for what happened. This is the impracticability contract. So you may ask, how does this apply today, Joe? And how does this apply with the coronavirus? So let's take a look at an example. I found an article and I'll link to it. It says the coronavirus could cost NBA players $654 million in salary. NBA players could potentially lose $654 million in pay if the global coronavirus wipes out what's left of the 2019-2020 season. The NBA's roughly 450 players across 30 teams usually get paid twice a month, though individual contracts vary. However, if there are no games, no paychecks. Commissioner Adam Silver suspended the 2019 season on March 11th for 30 days. If the season is canceled, the NBA would lose up to 250 games through the last day of the season on April 15th. If canceled games are not made up, players could take a big hit in their bank accounts. Okay, for example, LeBron James could lose an estimated $9 million in salary. Now, here's the kicker. Under Article 39, Section 5 of the NBA's collective bargaining agreement, players can lose it's a funny number, 192%, almost basically 1% of their salary for every game canceled due to a force majeure event, according to ESPN. So-called force majeure events under the current CBA include epidemics, wars, and terrorism. Okay, so that tells you everything you need to know right there. The collective bargaining agreement that the NBA has between the owners and the players provides for these events. So in the three-step analysis that we did, force majeure, foreseeability or superseding event, and impracticability, the court would stop at step one and they would pick up the contract and they would say, look, you guys planned for this right here, so this is what we're going to do. So the NBA players agreed in an event like this that they would lose 1% of their salary. It's actually a little more than 1% of their salary for every game that was canceled due to a force majeure, which means an unforeseen event. And they specifically included an epidemic or a pandemic, a virus outbreak like this. So there's no need to go to the next two portions of the analysis. In the collective bargaining agreement, the NBA and the players, they specifically negotiated this aspect. Therefore, a court is going to enforce it. You may say, well, this seems unfair to the players, but the players agreed to it. Therefore, a court would enforce it. The lesson from this is that it's a good idea to try to plan for these types of events in your contracts, especially big time business contracts, but even in smaller contracts. Let's say, you're getting your house redone, or a company's redoing a kitchen in your house. You might want to have force majeure clause in there in case you live in an area where there are let's say tornadoes in the Midwest, or a floodplain, or somewhere where a hurricane could damage your property. It's a good idea to have a force majeure clause in any contract. Otherwise, you're left to the mercy of the court. And remember, you could always make the force majeure clause be favorable, like the NBA players. They might have lost something or they might have gained in somewhere else in the contract by giving up a lot in the force majeure clause. They just assumed that clause would never be activated, and frankly, it probably hasn't been activated at least since 9/11 in the world of sports, but 9/11 even only caused a temporary delay. I don't know in my lifetime, I don't know if this is true or not, but I can't remember an event like this. So this is how the coronavirus, these unforeseen events like viruses, like natural disasters, like wars, can affect contracts. You do that three-part analysis: force majeure, superseding event, and impracticability, to see whether one of the parties can get out of responsibility for the contract. So I hope you found this informative and interesting. I know it's a lot to take in. Go back, watch it again, jump to certain parts. Thank you for joining me. I'm Joe the Lawyer. I tried to touch on the coronavirus and how it's going to affect businesses today, and try to give you some really useful information. Please like, subscribe, comment, and share. Also, I have an email list. Sign up for my email list. Get a free PDF on what to do when stopped by the police. Joe the Lawyer out.